going to quickly call together the work session of the SB 296 Subcommittee. And so we're going to be having the pledge shortly when the full committee comes. So we'll forego the pledge right now in favor of basically having that for the full committee, and just kind of go straight into it. So we had, I think, a couple of sessions where all of us learned a lot. I know that I did, and I think we were all in a position at the end where we were comfortable with the fact that the original bill as submitted was not going to be a bigger burden on the commission than it already has in front of it. So, with that going forward, what I would like to do is recommend to the full committee that we're looking to go forward with recommended for future legislation, with some of the follow-up items that we kind of talked about. We talked about the concern with the caseload, and we talked about the fact that their rules need to be brought up to date. So I think with that, I pretty much submitted the bulk of what I have to say to the bulk of the subcommittee. I did get an email from Jay Henry, who is the director of performance audits for the state, and he did say that the LPAOC is going to meet on November the 10th. He didn't specify exactly what time yet. There were a couple times he threw out, and the location, but once that's kind of firmed up, it's my intention to go and speak before the LPAOC, to say that the subcommittee, and hopefully we can convince the full committee, would like to have a performance audit. And Representative Smith has indicated an interest in participating. So if anybody else was interested in doing so, I do think it would add weight. I know that there's probably a lot of areas that are going to be in competition, and there's only so much room that they have to navigate. So anything that we could do to kind of strengthen the case, I would certainly appreciate. But beyond that, I did get some minor corrections from Jen relative to some of the formatting, and the only substantive change that she made is in my original blurb. What did I say? Rules would be brought up to date. So she added to that rules brought up to date and approved by the Joint Legislative Committee on Administrative Rules. So that was just a minor addition that she made to what I wrote. So basically just where in that bottom paragraph where it says that the rules be brought up to date, and she's adding the words "and approved by the Joint Legislative Committee on Administrative Rules." Okay, so that's basically where we're at. Does anybody have any thoughts or concerns on that before we go to the full committee at 1:30? Well, this was short and sweet then.
Short and sweet, we
Yeah,
love it.
you got a question?
Well, would you like a motion to support or approve your committee report?
That would be, I would prefer a motion to support it, yes. Would you be interested in making such a motion?
I would be pleased to make a motion that we, I guess, adopt as a result of our committee efforts, that we adopt the committee report which you got.
Okay,
And I'd be happy to second.
all right. Well, I appreciate that, both of you.
Right.
You want to speak to that?
Yes, I'd be happy to speak to that. And just because I didn't have my mic on before, I'll say that I'd make the motion to adopt your committee report.
Okay.
And I have to say that the committee, which was well led by its chair and much appreciated, I think provided lots of information to us with regard to the Human Rights Commission. And I'm absolutely convinced that changes need to be made to make the Human Rights Commission more responsive to the people of the state. And that the current system, as it is established and in large part established by statute, but as it's being implemented, just is taking too long and just is not workable, and I don't think it can continue to work in the manner in which it is. And I recognize that the director and other people at the commission are attempting to make change within that and within those parameters, but I don't think that we can wait for a long period of time. First of all, I'm not sure that the changes that have been talked about really are going to bring about the type of success that we would like to see happen out there, but I'm just not convinced that the current system can work for the people of the state, and will hopefully in the future see major improvements and changes made beyond what we're coming out with in our report today.
Well, I think I agree that we all had some major concerns. Having kind of sat through the reporting on the parole board and the amount of depth that they went into, my hope really is that having a performance audit will get into a lot of the depth that we just weren't able to do. I mean, what we were able to do was really uncover a lot of problems, but I still don't think at the end of the day we were able to drive to all the solutions. And so I'm really hoping and that we're successful with the application for the LPAOC. Representative Smith?
Thank you, Mr. Chair. I feel confident in being able to speak for every member of this subcommittee that we became aware of circumstances that, through no particular fault of anyone, result in unconscionable, and that's a strong word, unconscionable circumstances faced by people who have gone to a state agency to ask for help. To wait 2 years, 3 years, 4 years before there's resolution is not acceptable. It's wrong. To have clear expression by the leadership of the commission that they don't have the resources they need to carry out the law and the rules as they are required to, that is pretty serious. They find themselves in a position where they feel they have to, I guess, play the hand that they've been dealt, and try to make the best of it. The one example that stands out is by coming into us and telling us that they knew that the backlog was terrible and the caseload was terrible, and they've been able to cut that in half. And when we asked, how did you get more money? Did you get more staff? No, they just took half of the complaints and put them on the back burner. And that's not something that anybody should be expected to do or anybody take pride in. And we as the legislature have an obligation to make sure that people who think we have in place a system to help them, to make sure that we do in fact have a system to help them. So the work that was done under the chair's leadership is very, very important. And the report is worded, I think, skillfully and carefully, not to gloss things over, but also not to resist the temptation for a vendetta. So thank you, Mr. Chair.
Any other thoughts or comments? All right, well, let's, I'll adjourn this meeting then, and I will see everybody.
Maybe we should vote.
Oh, we vote for the motion.
Motion to accept the report.
What's this?
Yeah.
On the motion to accept the report on Senate Bill 296, all in favor, say aye.
Aye.
Opposed? It's a unanimous 5-0 vote. Thank you, Mr. Chairman.
Thank you, Representative Wolfer, for reminding me of our realities. Okay, so with that, we're adjourned, and we'll see everybody back at 1:30 for the full committee.
Okay.
Call this meeting of the House Judiciary Committee to order, and we'll begin by pledging allegiance. And Representative Andrus, would you like to lead us in the pledge today?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. And first of all, it's just nice to see everybody again. And Mr. Clerk, would you like to call the roll?
Thank you, Mr. Chairman. Representative Alexander or substitute? So that's, I could do this. I'm gonna do this, just write down Johnson. I know what I mean. Representative Andrus?
Yes.
Representative Birch? Substitute?
We have two substitutes that I don't know. Mr. Chairman, you would know who's for who.
If you pick one, it doesn't matter to me.
Representative Ron, do you know whether you're here for Representative Birch or Representative Kent? Okay, so that means Representative Prescian is here for Representative Birch. Chretien.
Chretien. Oh, this is going to be fun. Okay, Representative Chase. Representative DiLorenzo. Representative Gordon.
Here. Oh, no.
Excuse me, Representative Wolper. The committee assistant says it's the other way around.
Oh.
All right, wait a minute, hold it. So we're going to have,
Oh. Birch.
so Representative Cressy is here for Miss Representative Kenny. All right. Birch. Who is it? Oh, wrong. Okay, so far so good. We're making progress. Now, if you were me, you wouldn't be on opposite. Alexander is Johnson. All right, Representative Green. Representative Nodder. Oh, I went the wrong way. I'm gonna find you on this sheet. Okay, go back this way. Representative Horgan,
Here.
Representative Kelly. Representative Kenny is actually Representative wrong. Oh no, she's correct. It doesn't matter. But believe me, nobody knows what happens to this piece of paper. And now I have corrected that in all.
Need to know basis.
Representative Langley,
Here.
Representative Macbeth,
Here.
Representative McLean,
Here.
Representative Murner,
Here.
Representative Nodder, I already called, Representative Page,
Here.
Representative Simpson,
Here.
Representative Marjorie Smith,
Here.
Representative Sylvia,
Here.
Representative Trottier. Going once, going twice, not here,
Did
and
you get it?
Huh?
Representative Trottier?
no.
Here.
Well, where's
No,
He's not
forget
here.
it.
I didn't see him.
It's been a long summer.
And Representative Welper is here. So we have a quorum. In fact, we have, what, 18, 19? I'll have to count them.
Thank you, Mr. Clerk. Thank you, Mr. Clerk. We have today, our purpose of our meeting today is to vote on reports on our retained bills. We have 8 retained bills. I did send around our interim study bills, and I did send around a list of those bills and the reports that were published, the committee reports that came out in our calendar. I would say that we already had a meeting on this back on June 8th. there was a minority of the committee that did attend that day, but we did go through the 8 interim study bills. 5 of the bills we indicated that we thought were fairly easily disposed of with recommendations. 1 bill we decided to create a study committee, which we'll hear about later, and 2 bills we felt that it was necessary, that we couldn't come up with a recommendation on, and felt that it was better to have the full committee act on those. I did prepare some committee reports on the bills that we did act on that day, but we didn't have a majority of the committee that day, and I think we still need to have the full committee vote on those bills. And what we'll do is we'll go through the bills in order, by order number, on the sheet that you see here. And we'll begin with House Bill 124. And what I'll do is try to give you a little bit of, tell you what the committee did when we met back on June 8th, and then you can decide what you would like to do today. I don't think we need to have a lot of discussion today on these bills, and because the committee's already had a lot of discussion on these bills when we heard them the first time. And so I don't think we need a lot of discussion, but I'll entertain what conversation I think we need to have in order to make our recommendations as required. So the first bill is House Bill 124, adopting the Uniform Real Property Transfer Act on death. And when the committee met back on June 8th, the committee voted unanimously to recommend for further legislation. Right now there is the real estate probate practitioners are putting together a revised proposal. And I have an email which I just received from Elise Salick. And if you remember, Elise Salick was the attorney who spoke and I think pointed out many of the flaws in the proposal that we had before us that day. And she says, I'm emailing you to update the status on a new proposed transfer on death statute. We have drafted a totally new statute based on the Uniform Act, and our drafting group met today to review that initial draft. We've divided the statute into manageable sections, each of which will be reviewed and edited by our committee. This is a complicated statute, and we need to carefully consider how deeds will be created and how our new statute will tie into our existing probate laws and our existing real estate conveyance statute and our disclaimer statute and our durable power of attorney statute. We'll be meeting again toward the end of October to share our revisions, and we are working diligently on the statute. So, and I responded to that by saying that we needed to have that done by November 1st so that it could be brought forward as a statute. So with that, I guess we had previously recommended it, or the small committee had recommended it for further legislation. And I don't know if other people have other thoughts about that. Representative Smith.
Thank you. I do have a little question about your comment, Mr. Chair, when you said you told her that you needed to have something by November 1st to I don't see that. By November 1st, we have to make a recommendation, but we don't have to write an LSR. We don't have to have language, so that that November 1st is only for us, not for her. It would be after that. But I think that if I remember correctly, the conversation that took place around this and then the Senate bill that we will also hear, that they're very similar. In the Senate bill, there was also an amendment suggested, I believe, by Senator Quokka about making sure that no one was forced to become a beneficiary against their choice. So that I think what we agreed to was that we supported the concept, but did think that language to be considered by the next legislature would have to address a number of concerns, including but not limited to the opportunity for the beneficiary to say thanks but no thanks.
I think that's correct. And the reason I said November 1st wasn't for us to do our recommendation. I think the reason I said that is because the filing period, I believe, starts on November 9th. And so if we wanted to be able to file legislation for next year, it had to be timely. Does somebody want to make a motion?
I'll make a motion to recommend for future legislation.
Okay, moved by Representative McLean, seconded by Representative Nodder, that we recommend House Bill 124 for further legislation. Are you ready to vote? I see lots of heads nodding. And Mr. Clerk, would you like to take a roll?
I would. On the motion of recommending for future legislation, House Bill 124, Representative McLean,
Yes.
Representative Sylvia. Clerk votes yes. Representative Johnson,
Yes.
Representative Nodder,
Yes.
Representative Murner,
Yes.
Representative Kelly, Representative Andrus,
Yes.
Representative Smith, Representative Ron,
Yes.
Representative Horrigan,
Yes.
Representative DiLorenzo,
Yes.
Representative Chase,
Yes.
Representative Cretion,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Representative Gordon.
Yes.
That makes it unanimous. Should be 19, right? Yep. 2, 3, 4, 5, 6, 7, 8. 19 to 0. 19 in the affirmative, 0 in the negative.
Thank you.
Mr. Chair,
Yes.
could you refresh my fading memory about the procedure? We've taken a vote. Do we have a blurb, a report that gets submitted also, or is there no report for this?
There is a report, and the reports will appear in the calendar.
Thank you. And would the report then indicate that while we're recommending this for further legislation, we believe that there are ways that the bill must be improved?
Yes.
Should be improved. Thank you.
In fact, I already prepared a report,
That's why I made the.
which I would be glad to read to you. And I said the bill clearly has merit for people who wish to pass property on to others without the formality of probate administration or the creation of a trust. However, the initial bill lacked protections against fraud and undue influence. Therefore, the committee decided that it needed more work. Estate planning practitioners have been working with the committee to revise a proposal which will be acceptable for future legislation. Would that look okay to you, Representative Smith?
It looks perfect. Thank you.
The next bill is House Bill 248, relative to the Judicial Retirement Plan. And when we met back on June 8th, the committee at that time voted unanimously not to recommend for further legislation. And just by way of background, when it was presented to us, by Representative Lynn at the first instance, and indicated that they needed to do an amortization study to determine what the effect was, because I think the intention was that it could end up costing the state less if we changed the plan so that judges had to work longer in order to obtain their pension, and that the pension benefits would not be as rich as they currently are for judges. And I shouldn't say rich, as lucrative. And so they did the amortization study, and I think the result was the amortization study showed that basically there wouldn't be, if they changed the plan, there wouldn't be that much of a substantial savings so to the state. And any savings that would occur would be over a extremely long period of time. So I don't think there was any continuing interest in pursuing the bill. Representative Smith.
I have it in front of me. I should know the answer to this. That language wasn't retroactive, was it?
No, it was not retroactive. It would apply to new judges only.
Thank you.
Sir, any discussion or motion? Representative Smith.
Mr. Chair, I move that we not recommend House Bill 248 for further legislation.
Second.
Moved by Representative Smith, seconded by Representative Wolper, that we not recommend House Bill 248 for future legislation. Any other discussion? Seeing none, Representative Wolper, Mr. Clerk, would you like to take the roll?
I'm not recommending House Bill 248 for future legislation. Representative McLean,
Yes.
Representative Sylvia. Yes. The clerk votes yes. Representative Johnson,
Yes.
Representative Green, not here, sorry. Representative Nodder,
Yes.
Representative Murner,
Yes.
Representative Kelly, Representative Andrus,
Yes.
Representative Smith,
Yes.
Representative Wrong,
Yes.
Representative Horgan,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Creasy,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page.
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
I have it 19 in the affirmative, 0 in the negative.
And we have,
Do you have a report written for that as well, Mr. Chairman?
I do have a report. Would you like me to read it?
I yield.
Yeah. I indicate in the report that it's not recommended for future legislation, that the bill would revise the calculation of retirement benefits for judges under the Judicial Retirement Plan. It would have increased the time that judges are required to serve in order to obtain full retirement benefits. The intent would be to reduce the contribution to be made to the plan by the court system. After completing an amortization study, there did not appear to be a substantial financial benefit, and no further effort need be made to amend the Judicial Retirement Plan. If that's okay with everybody. House Bill 379, relative to electronic notice. Again, at our meeting on June 8th, we voted to not recommend for further legislation. And basically it comes down to the idea of whether or not you want to change to do away with having newspaper publication and substitute it with basically web publication. This would have allowed cities, towns, political subdivisions to do away with newspaper publication for meetings and announcements. Any thoughts? Yep, Representative Horgan.
Yes, I think the newspapers still have a role in this. There are still like some people who don't use the internet who still subscribe to the internet, and then there's also like some stubborn old people like me who insist on still subscribing to the newspaper, even though it's getting smaller and smaller. I read the Union Leader this morning. It took me about 5 minutes, and the public notices were really like the most interesting thing in the whole paper. But that's and also the good thing about the paper is every copy is definitely the same. You can save the newspaper if there's something specific, if you're particularly interested in a case. And then also there are libraries, and there's newspapers.com, which archive these things, so you have a reliable record of what the notice actually said. And I'd be worried if it was all electronic, then the older messages would kind of disappear into the ether, as it were. Like, and I could easily also imagine some cases where there might be dispute over what it was the notice actually said in the first place. Where if we have it in the newspaper, you can dig up the old newspaper somewhere and see exactly like what it was it said. And then I don't mind subsidizing newspapers. As I said, that's pretty much the only interesting thing that's left in a lot of these local papers. So I agree with the commission's recommendation to not recommend it for future legislation.
Did you want to make that a motion?
Well, I can make the motion if you want me to. So I move that we not recommend it for future legislation. So.
And moved by Representative Horrigan, seconded by Representative Chase, that we make House Bill 379 not recommended for future legislation. Is there any other discussion? I know Representative Andrus, you felt strongly about it at one time, but.
Yeah, I feel very strongly about it because there are many, which I'm in the same group, older people who do not use the internet, and they find other ways to find the information they want. And even though newspapers are getting smaller and smaller, many people still subscribe to them, and that's how they get their information. And until everybody has computers and websites, et cetera, I'm totally against this bill. Thanks.
Thank you. Mr. Clerk, do you want to call a roll?
On the motion of not recommending House Bill 379 for future legislation, Representative McLean,
Yes.
Representative Sylvia. Yes. Representative Welper votes yes. Representative Johnson,
Yes.
Representative Nodder,
Yes.
Representative Murner,
Yes.
Representative Kelly. Yes. Representative Andrus,
Yes.
Representative Smith. Yes. Representative Wrong,
Yes.
Representative Horrigan,
Yes.
Representative DiLorenzo,
Yes.
Representative Chase,
Yes.
Representative Cretion,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
once again, we have 19 in the affirmative, 0 in the negative.
So we've adopted the recommendation of not recommended for future legislation for House Bill 379.
When is the report due? Or we've already prepared?
Actually, I have a report, which I've already prepared. So.
Do you have a report for all of the bills today?
No, I did reports for the ones that we addressed back on June 8th. So there were 5 that the committee, the members who met on June 8th recommended. And so I did a report on each of those 5 just to save us time.
Thank you.
And to save everybody else from having to write them. And then, and I've also included the report which Representative McLean has already done on his. So there are only going to be 2 reports that need to be done, and then we're going to figure out who has to do those today. But the report that I do have for 379 is the bill defines electronic notice and authorizes electronic notice in lieu of newspaper notifications in statutes that require a city, town, or other political subdivision to provide notice of a meeting, hearing, or other event. As print media evolves into more web-centered formats, it may eventually become outdated. However, many of our constituents do not have access to or utilize web services daily. In time, we may be able to transition to this type of format, but the committee believes that we need to include all citizens who want to keep informed of the activities of their government boards. That looks okay to everybody. Okay, and the next bill is a bill for which we made no recommendation at the last meeting, and that's House Bill 1181, allowing the biological father of an unborn child to petition the court for an injunction prohibiting the biological mother from having an abortion. And Representative Smith.
Thank you, Mr. Chairman. I would like to move that we do not recommend that this bill be considered for further legislation.
Is there a second to that? Who seconded it?
Representative Chase did.
Representative Langley.
Oh, Langley?
Yep. Any discussion? Yep.
Yes, I would be
Hold on,
happy
let them shake it.
to make this discussion. There actually has been some water either under the bridge or over the dam since we met in June, relating to issues of reproductive rights. But nonetheless, the core principles continue, and that is the right of a woman to control, to make decisions concerning her own body. I say that recognizing that there is not a uniformity of opinion, and I understand that, and give full credence to the views that other people have. But New Hampshire is a state that for most of its years has adopted the classic libertarian philosophy that government does not belong in its citizens' private lives. And this is one more example where the person most central to the issue should be able to decide who to consult, who to involve, who to help make decisions that affect her life and her future. And she might very well choose to have her partner, her spouse, perhaps, if it is in fact a spouse, her religious leader, and certainly her medical provider involved. But I don't think there's room for 424 legislators in the decision, and so that is why I believe it's not appropriate for further action.
I know that this is the bill which generates strong opinions, but I know that we debated this bill quite a bit already, and in our committee, I don't know that we need to have a lot of debate here today if you're willing to vote on the motion and move forward. Okay,
Speak?
would you like to speak?
I would like to speak.
Okay, you have a right to speak.
Thank you, Mr. Chairman, and I concur. We have discussed this at length. There was a significant division, at least in my mind, in the committee before, and which is why it's here for interim study. And contrary to the view expressed by the representative from Durham, this is a bill about the government not being involved. That's the point of it, is to allow the father, who is one of the two parents, to have some say in the life of the child. And the bill before us, as it was written, recognized that the mother's rights were preeminent and the father's rights would be subservient. but that the father should have rights. And I say, why wouldn't the father? The father should have the same, I don't know, reproductive freedom, if you want to call it that, as the mother. So I will be voting that we should recommend it. And that's as far as I need to go with that.
Okay. You ready to vote? Okay. Mr. Clerk, would you mind calling the roll? This is on the motion to recommend, not recommend for future legislation.
This is
House,
by,
House Bill 1181.
yes, but by whom? And
It was, the motion was made by Representative Smith, seconded by Representative Langley.
Okay. On the motion of on the motion of not recommending House Bill 1181 for future legislation, Representative McLean,
No.
Representative Sylvia. The clerk votes no. Representative Johnson,
No.
Representative Nodder,
Somebody will put in a bill anyway, so I'll go ahead and vote yes.
Representative Murner,
No.
Representative Kelly, Representative Andrus,
No.
Representative Smith,
Yes.
Representative Wrong,
Yes.
Representative Horrigan,
Yes.
Representative DiLorenzo,
Yes.
Representative Chase,
Yes.
Representative Parisian,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
that should make it 12 to 2, 3, 4, 5, 6, 7. They should make it 12 to 7. 12 in the affirmative, 7 in the negative.
Representative Smith, will you do the report?
I'd be honored to, Mr. Chairman. No, actually, I'd be willing to.
House Bill, yeah, so we've voted 12 to 7 to recommend no, to not recommend future legislation for House Bill 1181. House Bill 1389, establishing a Superior Court land use review docket. Again, when the committee met last June, it made no recommendation on this, waiting for the full committee to make a recommendation. I understand that from Attorney Head, that the court system has put in money in its proposed budget for the next biennium for the land use docket. Yes.
I'd like to make the recommendation that we not recommend it for further legislation.
Is there a second to that?
Second.
Seconded by Representative DiLorenzo. And would you like to address your motion?
I think that we've had the land use board and appeals board in which was a different change, affected land use law in action now for 2 years, and it's working pretty well as far as speeding up the land use docket. I also feel like to carve off this section might make may start if they're just delegated to one judge, there may be some bias that gets reinforced in that over the years. And I also think the testimony, there really was this was not really clearly needed or desired by the practitioners or the court. So I'd like to just wait on this for a little while.
Any other discussion? Representative McLean.
Thank you, Mr. Chair. It is my understanding that while the court did not testify in favor of it at the time, they did come back to us after and say, yeah, this is something actually that they would be in favor of. And in fact, as you mentioned, that they were looking to put money in. And And the reason for that is because they see a lot of inconsistency with respect to how the law is being applied. So towns would still have the same flexibility to make their own, bylaws and rules. It's just that how it's applied in the courts, the hope with this is that you're going to just have more consistency with respect to the decision. So I'll be supporting it.
Representative Smith.
Thank you. Mr. Chair, would it be permissible to you and the committee if we asked Mr. Head to answer a couple of questions? Which is appropriate if you're willing. You don't have to.
I'd rather not.
Okay. Then could I just make a couple of points where I won't have the opportunity to validate the
Yes.
accuracy, if I could.
Please.
I'd be curious if I were permitted to ask if the courts increased the bottom line of the request to the governor, or if they took money from some other purpose to apply it for this. That would be my first question that I would ask. My second question would be, how close is the court to having a full complement of judges in all the requisite court levels, so that it would not be required to take a judge from another purpose to use for this purpose? And my third question would be, would it not make more sense for the court to have an effective training program for its judges so that the inconsistencies are no more than the inconsistencies that you would have when reasonable people differ on certain outcomes, but nonetheless the decisions would be based on the law and regulations as they are. All of those reasons cause me to think that in due course this might make sense, but I do not have the verification that I would want to know that in fact the judicial branch is ready for this. Thank you.
Other discussion. Representative Horgan.
Yes, thank you. If we had passed this bill and signed into law, it would have taken effect January 1st, 2023, and then about five and a half months or so after that, we would have passed a new budget. So it would have been effectively meaningless, because one of the topics which is included in every, now I can't remember whether this is I guess things is an HB2, the trailer bill, but in any case, every budget there's always a debate over the number of superior court justices we should have. So essentially, we'd be adding one, but there's no guarantee we wouldn't be taking one away immediately afterwards. In fact, we probably wouldn't even have been able to hire the person and confirm them before the budget process was done. So I think a standalone bill is unnecessary, and certainly absolutely it's not at all a surprise to discover that this is already going to be an issue in the next budget, because it's always an issue in the next budget. And certainly the basic concept is an interesting one, but the next finance committee will be dealing with that. So I don't think there's any need for us to make any recommendation now. So I agree with the not to recommend for future legislation motion. Given that I know there's a bill which will have this along with many other issues coming down pretty soon, and if I'm lucky enough to be reelected, I'm sure I'll be able to vote on that, and I'm sure we all feel the same way. Thanks.
Any other discussion? I have to say that I'm torn on it. I think the issue for me is, do I think it would be good to have a court with a land use docket? And the answer to that is, yeah, I do. And I do because one of the advantages of having every lawyer knows that when you go to court, if you know the judge, you have an expectation. You generally have a sense of how a judge is going to rule, and it makes the law much more predictable and practical. And if you focus on land use, you can make the time frames, because one of the big problems with land use cases right now is they take forever, and it discourages everybody from being involved. If you want to contest a zoning board decision, or if you're a developer and you want to put in a development. And so I think the land use docket has the other side of it. So I think generally, yes, I would look for future legislation to have a land use board. It makes sense to me. But the issue I have right now is the status of the courts, because the courts aren't operating very effectively right now in terms of their time frames and getting things done, and the backups in the court, and saying, well, geez, do you want to create a new program when the court's backed up? And that doesn't make sense to me. But so I think I'm going to, without any offense, I think I'm going to oppose because I think it's a good idea for the legislation. I'm just not sure how practical it is in the world. So, long and short. Mr. Clerk, you want to call a roll? And the motion is to recommend no further legislation on House Bill 1389.
On the motion of not recommending House Bill 1389 for future legislation, Representative McLean,
No.
Representative Sylvia. Clerk votes yes. Representative Johnson,
No.
Representative Nodder,
No.
Representative Murner,
No.
Representative Kelly, Representative Andrus,
Yes.
Representative Smith, Representative Ron,
Yes.
Representative Horrigan,
Yes.
Representative DiLorenzo,
Yes.
Representative Chase,
Yes.
Representative Friesen,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page.
Yes.
Representative Simpson,
Yes.
Mr. Chairman.
No.
1, 2, 3, 4 makes it 14 in the affirmative, 5 in the negative.
I think I'm going to vote in favor of further legislation.
That was against.
Okay, so we've voted 14-5 to recommend no further legislation for House Bill 1389. Which brings us to House Bill 14N. Who would like to do a report on House Bill 1389?
I'll make the motion, Mr. Chair. Or did you?
Oh, just hold on. On 13.
Yes, I will. I would be happy to write the report.
When can you get that to me?
I promise. When do you want it today?
Yeah, that would be great.
Okay.
Do it today. Okay. Thank you. House Bill 1435. Relative to the right of a victim of domestic violence to have a support person present when testifying or being deposed. And when we did meet on June 8th, we did have the members that day voted unanimously to recommend no further future legislation.
I wasn't here.
And I guess I'll open it up for discussion or for a motion. Yes, Representative Nodder.
Thank you, Mr. Chair. I wasn't here that day. I don't remember why. But I liked this bill, and I thought it had a lot of merit. I spent time this morning going through the emails that we got in support of the bill with recommended changes. And then I see somebody provided us all with a copy of that. So I would be happy to recommend further legislation on this.
Okay. Is there a second to that?
Second.
moved by Representative Nodder, that we recommend future legislation, seconded by Representative Wolper. And any other discussion? Representative Nodder, do you want to speak to it further?
No, we can vote on it.
Representative Macbeth?
So I just am going to say I think that this issue is important. I think that the commission, the Domestic Violence Commission, is doing a lot of good work, and I understand that they're reviewing all the protocols regarding domestic violence. So I'm respectfully not going to support this bill, because I think there's going to be recommendations that are going to come in that really are going to focus the way we need to go. Thank you.
Yeah, Representative Wolper.
Thank you, Mr. Chairman. If we're going to have future legislation and we know it because it's such an important issue, why wouldn't we just recommend for future legislation? That's what I'm going to do.
Yeah. Well, I think the issue, in fact, you could vote for future legislation for any subject matter, but I think the question was whether or not you recommend this bill for future legislation. So, and I think that's what the concern, and the concern that I had with the bill, and that is, if you read the bill literally, it says a support person provided for any party, which means not only would you be providing representation for victims, you could be providing a support person for a perpetrator. I don't think that was certainly the intention, but I think that's the way the bill is written. The one thing it says is that the bill says is that it absolutely says the judge cannot control the support person, has no authority over the support person. So the support person could get up and rant and rave in the court, and the judge can't do anything about it. The court person could swear in the court, can't do anything about it. The support person can engage in, be noisy, disruptive, argue with the other party. Judge can't do anything about it the way the current bill is written. And that doesn't make any sense. It raises some other issues with regard to the intention part was, and I think there was testimony that the support person be able to go up on the stand while a person is testifying. How does that prejudice a jury? Does it prejudice a jury? I think that's an issue to wrestle with. You know, we had a bill about allowing people to have dogs up there. We didn't want dogs up there because it would prejudice the jury. So you're going to allow a support person up there to do that. So I just, with all respect to Representative Gay, who I know is doing it absolutely what she believes is the right thing, I just don't see this bill as being workable. And the domestic, and I'll go one other thing I'd like to say about it is that we do have the Domestic Violence Task Force. They already came out with one report, and we do supply support persons right now through the local agencies. But when they came out with the task force, they said what people really need in domestic violence cases is not a support person. What they need is a voice. What they need is attorneys. Only 13% of the people who appear as plaintiffs in domestic violence cases are represented by an attorney. Defendants are more likely to be represented by attorneys. Many of these people are intimidated by the court system. They don't know what to say. There's a legal standard that you have to prove. You have to show that they've engaged in behavior which is effectively a criminal act. They don't know what to say. They don't know what to do. And what they really need is a voice. What they really need is somebody to speak on their behalf in many cases. And so, long and the short is, I can't support the bill because the way it's written, I just don't think it's workable at all. In fact, I think it's harmful. And yes, it could be modified, but just to say, well, you know, we could come up with a better plan for domestic violence. I think that's true, but I think the coalition, not the coalition, but the governor's domestic violence task force could do that too. That's long short. That's it.
So just to, I agree with that. And Representative Gay, I want to say, you know, I have worked for 15 years with Haven on the Seacoast and representing women in their final domestic violence restraining orders. And also in my family practice, I work some. But the issue is a lot of times the victim, it's not only the defendant that she's getting able to get the temporary restraining about, it's a dynamic within the family. And if you have someone that's untrained supporting them, it might be someone that's part of that system. An example of a family member that needs housing. And so they're supporting that victim, but really they also have, you know, just she's worried about, my kid's going to lose housing, or is my son going to lose housing, you know, or my adult people. So I think it's dangerous. And I've seen it when you have an untrained advocate. You know, luckily in Rockingham County, most every of our, you know, anyone that contacts Havens does get an advocate, and I support advocates. So when you ask me, Representative, why not support this? Because I do see it very destructive to have somebody that is not trained and the court can't control, because that's going to reflect badly. So I do, I think the legal representation is critical. Advocate that's trained in trauma is critical, but I think other people, as well-meaning as this bill is, would be very destructive. Thank you.
Okay. And I guess you could call the roll, unless there's somebody else.
Oh, I thought you were going to speak.
No.
Okay, on, what are we at? 1435, right? Not recommended. Right?
The motion was recommended, right? Or
The motion is
Oh, to recommend.
to recommend.
So I had. Okay. So on the motion to recommend HB 1435 for future legislation, Representative McLean,
no.
Representative Sylvia. No. Clerk votes yes. Representative Johnson,
No.
Representative Nodder,
Yes.
Representative Murner,
No.
Representative Kelly, Representative Andrus,
No.
Representative Smith. No. Representative Rung,
Yes.
Representative Horrigan,
No.
Representative DiLorenzo,
No.
Representative Chase,
No.
Representative Grecian,
No.
Representative Langley,
Yes.
Representative Macbeth,
No.
Representative Page,
No.
Representative Simpson.
No.
Mr. Chairman.
No.
I have it as 5 in the affirmative, 14 in the negative. I have myself, Representative Nodder, Representative Wrong. That would be only 4. 1, 2, 3, 4. Okay, so I have 4 in the affirmative.
Did you have
Oh,
Langley?
1, 2, 3. Yes, Representative Wrong, Representative Langley, and Representative Welper and Nodder. That's 4 to 15.
And I would move to not recommend for future legislation. I'd make the motion to not recommend for future legislation, seconded by Representative Macbeth. And I think we've had our discussion. Mr. Clerk, are you ready to call a roll
I
again?
am not ready. I will be quite shortly. Okay, let's see if I can do this. I'll try it this way. On the motion of not recommending House Bill 1435 for future legislation, Representative McLean,
Yes.
Representative Sylvia. Yes. Clerk votes no. Representative Johnson,
Yes.
oh, he's just not here. Representative Nodder,
No.
Representative Murner,
Yes.
Representative Kelly, Representative Ron? No. Oh, that's Cartier, he's just not here. Representative Andrews,
Yes.
Representative Smith. Yes. Representative Ron,
No.
Representative Horgan,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny, Representative Friesen,
Yes.
Representative Langley, Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Chairman.
Yes.
This is 15 in the affirmative, 4 in the negative.
So we'll adopt the recommendation of not recommended for future legislation by a vote of 15 to 4. Senate Bill 243, permitting transfer of death on deeds for real property. This is a bill which is nearly identical to the first bill that we discussed. Somebody want to make a motion?
I'll make a motion to recommend for future legislation.
Moved by Representative McLean and seconded by Representative Macbeth. Any discussion? Seeing none, Mr. Clerk? Just to keep you busy, you'd like to call the roll? This is on a motion of recommend for future legislation for Senate Bill 243.
Didn't even mark what it was. It's not recommend, right?
It's recommend for future legislation.
Okay, recommend. On the motion of recommending Senate Bill 243 for future legislation, Representative McLean,
Yes.
Representative Sylvia. Clerk votes yes. Representative Johnson,
Yes.
Representative Nodder,
Yes.
Representative Murner,
Yes.
Representative Kelly, Representative Andrus,
Yes.
Representative Smith. Yes. Representative Ron,
Yes.
Representative Horgan,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Creation,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have, oh, it's not the right one. I have it at 19 in the affirmative, 0 in the negative.
And so you voted to recommend for future legislation Senate Bill 243. Which brings us to our last bill. Kurt, do you want to pass that down? Our last bill, which is Senate Bill 296, relative to complaint procedures in cases before the Commission for Human Rights. This is in fact a bill where we had a subcommittee, and call upon the chair of the subcommittee to make a motion if he wishes to do so.
Yeah, Mr. Chair, I would make a motion that we recommend for future legislation.
Excuse me. Moved by Representative McLean, future legislation, and is that seconded?
Second.
Seconded by Representative Nodder. Would you like to address your motion?
Yes, thank you, Mr. Chair. So, the original bill SB 296, as it was presented to the committee, basically what it did is it eliminated the right of the respondent to remove the case being brought before the Human Rights Commission to the Superior Court after a finding of probable cause. And so the intent of the bill was basically the claimant has gone all the way, to the 5-yard line, and at which point the whole game gets moved to a different stadium. And so when we looked at it, actually 48 states do not allow the removing by the respondent to the Superior Court. There's only 2 states, of which New Hampshire is one. And our law that allows that removal was basically modeled after a Massachusetts law, which the Supreme Court found to be unconstitutional because the claimant has the burden of proof, the heavier burden of proof in the case. They're the ones that get to choose the forum. And so from a constitutional legal perspective, everything about SB 296 was okay. It's fully constitutional. Everything was good there. The concern that we had, and the reason that we decided to pull it off for interim study, was there was concern that the Human Rights Commission was just overburdened, and if there was not this right of removal, then all of these cases are going to end up staying at the Human Rights Commission, and the commission, which is already bogged down, is going to be bogged down even more. So what we did is we went and we gathered data, and we talked about this in the subcommittee. We looked at the removal rates basis versus the amount of cases which are being brought on each month by the Human Rights Commission. And when we looked at that, we really found that this is not a significant burden for them to be taking on outside of what they already had. So from a legal perspective, SB 296 was sound. And from an additional burden, we're talking, maybe 10 cases a year are being removed from the Human Rights Commission to the Superior Court. And the Human Rights Commission is actually taking on 20 to 30 cases a month being docketed. So we really didn't see any barrier there. But the bigger concern, and where we kind of started to look in a little bit more detail, is just the effectiveness of the Human Rights Commission itself. And the Human Rights Commission, basically, they're in a state right now where they're kind of in steady state. So if they have 20 or 30 cases coming in a month, they have 20 or 30 cases coming out. But they have this backlog of about 300 cases that really are just kind of hanging there. And so if you kind of address them on a first in, first out basis, in many cases, people are going in the extreme to 5 years before they get to a probable cause hearing. So the statute really says that you have 2 years to basically to get to that probable cause resolution. So they've been working with the Attorney General's department. They looked at streamlining certain elements of the operations. We'd asked for some data around that, just to basically look at from the time that an investigator is assigned to a case to the time that probable cause is found. Has anything shifted with that? We really weren't able to get at that data. But what we did understand is that turnover has been a real problem at the Human Rights Commission. Stability has been a real problem at the Human Rights Commission. And so Representative, DiLorenzo, looking at basically the breadth of the problems that they had there, said maybe there would be some benefit in actually having a performance audit done of the Human Rights Commission, similar to that which had been undertaken of the parole board. And so I did speak with the Director of Audits, and we have a hearing coming up on November the 10th for the the board that basically is going to make the decision as to which performance audits are taking up. So in addition to, basically recommending that the legislation go forward, the three additional recommendations that we are looking to put into the committee report are: number one, that we push for a performance audit to be done, and we will be going up and making the case on November 10th for that. Also, that the rules of the Human Rights Commission be brought up to date. One of the things that came about as part of the testimony of the subcommittee is that they have been operating without rules for the last 5 years. So basically, we want to get those brought up to date and approved by GELCAR. That's something else that we want to push for. And also a review as to what resources are needed basically to allow them to fulfill their mandate. Their resources were cut back. It used to be 10 years ago that it was a 1-year limit to get to probable cause. When resources were cut, that was moved out to 2 years, but they're not even meeting that. So those are the three additional recommendations that the subcommittee is going to be putting in the committee report. But we are going to be recommendation, the SB 296 as it was, we didn't see any problem with that, and we're going to be recommending that for future legislation. So we hope you'll support that.
Any other discussion? Representative Smith.
Thank you, Mr. Chair. I think we shouldn't let this go by without first commending Representative McLean, who did an incredible amount of work under difficult circumstances, not hurting the cats who were on the committee. We were fine, but getting the information from those people who had access to the data that we needed. It was not easily done. None of us felt the need to assess blame on anyone. But I think I can speak fairly for my colleagues on the subcommittee to say that we were shocked and saddened to realize that there are people in the state who, because we created a Human Rights Commission, believes that there was someone who would pay attention to their concerns. And in fact, that is not what is happening. The one most shocking example is that there came a day when representatives came in and said they had been able to address the backlog and cut it in half. And we were excited about that. We thought that was fabulous. That was terrific. We thought, did they get more money? Did they get more staff? They had asked for more staff. Did the governor somehow, with all the extra money that's come in, find a way to help them? No. The way they defined cutting the backlog was they took half of the cases and they removed them from the investigators' desks and put them in a box someplace, literally and figuratively. And so now the investigators only had half as many cases. But the people who were depending upon us, the people of the state, to address their concerns had no help at all. And we all know that people, that the commissioners and other employees are in difficult position. They have to keep a stiff upper lip. They have to keep a smile on their face. They're given X amount of money when they think they need Y. They're given A amount of staff when they think they need B, but they just kind of go on. They don't complain, and they think they're being good sports and responsible to the people who appointed them. But they are responsible to the people of the state, and this body is not carrying out their responsibilities. So we really have an obligation to try to get the data necessary to change the game. And the performance audit route is a absolutely solid route here where trained professionals will go through. This is not a financial audit. This is a performance audit to look at how they are organized and how they might be able to change what they're doing in order to meet the needs of the state. So the tone that will go in a written statement will be less emotional, as is appropriate. But the reality is that we have a problem here and we are obliged to try to address it. And so I want to end with the way I began, which is to thank Representative McLean, who maintaining an even temper and a fair and open-minded approach really helped us through this process. So thank you, Representative McLean.
I also would just like to add that, my thanks as well to Representative McLean, who did a superb job in running the subcommittee. My take is a little bit different with regard to the performance audit. I think the performance audit will be great, but in large part, the commission is operating, first of all, just as unbelievable as it is, there's a statute that says that when the Human Rights Commission gets a case, it needs to complete the case within 2 years. The statute says that. Right now, they're completing cases in 3 years, 4 years, 5 years. Just totally unacceptable. And from my point of view, a person who is a litigant and knows that they're going to go to the Human Rights Commission should have a reasonable expectation that they should be able to get some type of answer within a year. It just seems reasonable, a year's time. But my concern with the performance audit, and I think it's a great idea and it'll evaluate it, but so much of what the commission does is based upon statutes that we've enacted and put in place with regard to investigators doing probable cause assessments and so forth. And I'm afraid that in the performance audits, they're going to measure the Human Rights Commission against the statutes that we put in place, where I think what needs to really change is the statutes that are in place to make it more effective and to make it work better and to serve the people of the state. And that is my only qualification. But I do think the performance audit is valuable and hopefully get it done. But if it were up to me, if I was still going to be here, I'd be putting in a bill to change the way probable cause is assessed and the way things are heard. Frankly, you'd have an expectation that the human rights commissioners are having hearings. They don't have any hearings. They have 3 or 4 hearings a year, if you can believe that. Just unbelievable. Anyway, I'm fully supportive of the motion. Representative McLean made the motion, and it was seconded by Representative Notter. And that is to recommend further legislation. And I think Representative McLean has already circulated the report that he intends to file.
That's gone around.
Yes.
Yeah, would you like to call the roll?
I would. On the motion to recommend SB 296 for future legislation, Representative McLean,
Yes.
Representative Sylvia. No. Representative Wolper votes yes. Representative Johnson,
Yes.
Representative Notter,
Yes.
Representative Murner,
Yes.
Representative Kelly, Representative Andrus,
Yes.
Representative Smith,
Yes.
Representative Wrong,
Yes.
Representative Horrigan,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Cretion,
Yes.
Representative Langley,
Yes.
Representative Macbeth, Representative Page,
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have an 18 in the affirmative, 1 in the negative.
Okay, you voted 18-1 to recommend for future legislation. Senate Bill 296.
Mr. Chair,
Yes.
I promise I won't take long. I do want to just take one quick minute to respond to your comments, almost all of which I agree with. But I have had great familiarity over many, many years, probably too many, with performance audits. And one of the important components of a well-constructed performance audit is a suggestion based on facts, data, findings, rather than on emotions, of not only changing rules and regulations and processes, but also changing the RSAs, where they very specifically say this RSA has to be changed. And I think, to get this issue out of the range of violins playing in the background and into a range when some hard decisions could be made, I think the performance audit will help. Thank you.
I think that about concludes our business today. Is there anything else?
Yes,
we need
Mr.
to-
Chair, I'd like to make a statement.
Yep.
So I think this is going to be the last time that we get together. So I just want to say it really has been an honor for me to be your vice chair. I've never served in the capacity as a vice chair, and I was very, very lucky to have you as chair. That you really led this committee in an exemplary manner in a period of increased rancor everywhere. The debate here was very, very principled, but also very professional and cordial. And that's getting rarer and rarer. And when I heard that you were not going to run again, for me, that was a very hard blow. And I'm really going to miss you, especially, coming right before that, I had Representative Smith as a chair. So this committee really has been very, very blessed, and I'm really going to miss you, sir.
Thank you so much. You don't need to do that. It's really it's been my honor to serve the committee. It's been my honor to serve the state, first of all, but it's been my honor to be chair. I was so very fortunate to be given this opportunity and to work with all of you. The committee, when I look at the other chairs and I look at the other committees and what they've gone through, this committee is exemplary in my mind in terms of the way that we got business done. We got a lot of business done, first of all. We got a lot of business done. We did it timely. We got it done. And we did it without any rancor or people really being jerks. It was really, really special. A lot of credit for that goes to Representative Smith, who is just in terms of opposite party, just perfect to work with. She was terrific too. So, and but all of you, it was just my pleasure to work with all of you, and I hope to have continuing contact with you in some way. So, and thank you so much. I even like Kurt Wolperson.
Oh, yes.
My normal, yes. The usual.
Representative Smith, could you do a report? You're going to do the.
Do you want my report?
Yeah. I don't need to have it today, but. Yeah. How about by the end of the week?
Hey, Judge.
Yeah, that's fine. That's fine.
So, when the estate group comes and gives you,
Yes,
Jeff was put in a bill. And he put
should be all there.
it was
If it's
be
not,
great if
you just have to call me.
Okay.
if you're having
Except for this.
communication with them.
That's
so
not
try to
there.
keep Jess in mind, so that we're not going down the same path we went down last year.
Okay.
And if they have that, like you said, November 1st.
My pleasure.
And I hope you will stay in touch.
Yeah.